Hey, 2033, it's Dr. Wilderman again. Today I'm going to talk to you about a few things that you should know at this stage in your major concerning media law. I'm going to try to be brief, though it is difficult to talk briefly about law issues as they can be complicated. Today we're going to cover just a few items concerning the First Amendment, types of speech that are not protected by the First Amendment, libel, some broadcast differences in broadcast regulation, copyright, fair use, and trademark. That's a lot to get through in what I hope will be about 20 minutes. All right. So hopefully you know about the First Amendment in the U.S. Constitution. So the First Amendment words I would like you to be aware of, they're here on the screen. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or of the right of the people peaceably to assemble and to petition the government for a redress of grievances. So the First Amendment is not just about freedom of speech, but that is the part that we're going to talk about. So if you'll note, it's about freedom of speech of all citizens, and then also specifically freedom of the press. So let's talk a little bit more about how we know that our First Amendment is holding up. So basically, if you are to be in a country that says that they have free speech, typically that means that you can pass this two-pronged test of free speech. So one, you have the ability to go unpunished after venting severe criticism of those holding political power. So, if you had written an opinion column or a blog post or a social media post, and you are very critical about an elected official, you should be able to do that and not be punished in any way. Second, can a government official check over what you have written or broadcast and deny you the right to publish it beforehand? That's referred to as prior restraint or pre-publication censorship. And so typically in the United States, we pass this two-pronged test. There are small ways in certain situations where we may not pass it. You'll go more into those in your media law class in the future. But typically we pass this two-pronged test. We have those freedoms. There is an organization called Reporters Without Borders, and they run a very cool website where they rate the freest presses, the countries that have the freest speech and the freest ability for the press to do their job. US currently right now ranks 45 out of 180 countries. We aren't the best, but we are definitely, in the upper percent of countries. In our history, we've been ranked as high as 32. But if people are saying to you that America has the freest press in the world, according to this organization, based on their parameters, we actually do not. We do well, but not perfectly. Okay, so then I want to talk about a few types of speech that are not protected by the First Amendment. In the US, we as in citizens, or we as in the press, as in media professionals, we have a lot of free speech protection, but it's not ultimate. It's not 100%. There are categories of speech that are not protected by the First Amendment. And how I want you to remember them is the acronym FIDO, FIDO. You're going to talk a little bit more about some of these in class. I'm going to give a really quick sweep of them. So F stands for fighting words / true threats. So words that are likely to instigate an immediate breach of the peace, that's fighting words, or words that are viewed as like true threats toward a person's safety. We don't have a right to those. For I in FIDO, incitement to violence or crime, words or content that are going to lead people to commit violence or crimes. And that was our intent. That was our intent. The words that we used, the content that we published, it was meant to incite violence. We don't have a right to that kind of speech. Defamation or libel is the concept that you might be more familiar with. Libel is a type of defamation. I am going to talk more about this in a minute. And so the D in FIDO is defamation, but tie that in your head to the word libel. And then the O is obscenity. And obscenity is a very narrow category of speech. It's not what people necessarily think it is. It's not just bad words. It's not just sexual content. There's a very narrow definition that the Supreme Court uses for obscenity. Okay, so let's talk a little bit more about the one element of FIDO that is most relevant to your upcoming assignments. All right, it's the defamation or libel part of FIDO. So the legal definition of defamation is right here. Communication which exposes persons to hatred, ridicule, or contempt, lowers them in the esteem of others, causes them to be shunned, or injures them in their business or calling. In a little bit of a simpler way, um, this means words or content that damage a person's reputation, truly damage it to where their life is different after the defamation takes place. Now, the reason I say to tie defamation in your head to libel is that libel is one type of defamation. Libel is defamation that is published. And by published, I mean published via any means of media, of mass media that you can think of. So if we're talking about a newspaper publishing, a book publishing, a website publishing, a broadcast that goes out across the airwaves or is streamed, content that we put up on social media, all of that is published in terms of libel. So we are not really ever talking about slander anymore, which is the other type of defamation. Slander would be defamation that is only spoken. And so when we're talking about defamation with broadcasting, it's not just spoken. Broadcasting is put over to the airwaves, put out there to the world. So just tie it in your head that defamation, when you're talking about it as a media professional, we are talking about libel. Libel is the most common media law issue that media professionals are likely to deal with in their careers. And it's not just journalists who need to worry about libel. Many libel cases are tied to journalism, but all media professionals, in fact, any person who's putting content out there on a platform, like a social media platform, anyone who is publishing content out to the world could commit libel and find themselves in a libel case. So every area in Gaylord needs to understand libel. All right. So again, remember FIDO, remember what that stands for. And that's definitely something that's going to come back up again on some quizzes and tests. All right. There's a few defenses for libel that we want to point out to you. And right now, the two that are most important for you to know, there's more later. But when something is true, that's a defense for libel. Remember that libel has to truly damage a person's reputation. And content that just hurts feelings or annoys someone or infuriates someone, that's not enough to be libel. But the thing is, when the content is true, journalists and other media professionals don't have to worry about publishing it. It might hurt their reputation, hurt a person's reputation, but if it's true, that's a defense for us as libel. So we're not going to go into a court case if we have published something that is true. So for example, if you write a story or do a television news report or a documentary about someone who is a convicted child abuser and you refer to them as a convicted child abuser, that person cannot successfully sue you for libel because it's true that they have been convicted of that. However, if you accidentally put the wrong person's name into that story, identify someone else as the convicted child abuser, that is asking for a libel case to happen. That's asking for the person who's been wrongly named to sue you or the company that you work for. Or the company that you work for. Libel cases can cost people a lot of money. They can cost an individual a lot of money or the company that you work for a lot of money. There's an example of recently the Oklahoman was involved in a costly libel case. So you can connect to that if you'll go to the PowerPoint presentation version of this. I have some links that you can connect to and read about that. Okay, the other element that is a defense for libel we want you to know about right now is opinion, because the thing is, if we have an opinion like I can't stand that person or that politician is doing a terrible job, opinion can't can't be the basis of a lawsuit because opinions can't be proven true or false. And so on the PowerPoint, there's some different ways that you can think about opinion, and I'll let you guys go over that yourselves or in class a little bit more. But the reason we bring up libel now, while you're about to embark on some projects where you are going to be interviewing sources and having your own story ideas, we want you to know that you should always be checking your facts, looking at the truth, not publishing anything that you think might be false, and definitely not publishing anything that you know is false. So going back, actually, I meant to say, this is one reason that all the 2033 instructors have to be tough on fact errors. Not all fact errors are potentially libelous. Some of them are just annoying, or might hurt someone's feelings or kind of make them mad. But not all fact errors are potentially libelous, but fact errors are how many libel cases start. And if you look at this story that the Oklahoman was involved in, I think you'll understand that a little bit better. Okay, so truth and opinion are defenses for libel that we want you to know about. Now, the book, we all as media professionals need to know how to avoid libel. We need to understand it and then work toward avoiding it. So the Filek textbook mentions 4 ways that you can do this. The first is just to check your facts. Check them and check them again. Because remember, if something is true, we are not in a position as the media professional to be sued for libel. But fact checking can be a little bit difficult. It's not just as easy as double checking that a name is spelled correctly. That's great. But sometimes you really need to cross verify your information. So don't just check a fact with one source, with one human source or one written source. Check in multiple places. And if you're hearing different information in different sources from different sources, go back and re-verify, check again, take the information from one source to another and say, hey, these 2 things seem to be a little different. Can you help me understand, right? So re-verify, cross-verify your information. The third thing the book mentions is not to extrapolate. So what that means is not to suggest more than you know for sure, okay? If sources are telling you, I think this might have happened, it's possible this might have happened, you can keep that in your mind, but don't put that into your story. Don't write anything that you don't know for sure into your story. And then another way to avoid libel is to take really good notes and to keep hold of them. Essentially, this is the modern day equivalent of having your own receipts, right? In addition into taking good notes, that could mean asking solid questions in your interview and then holding on to recordings if you used recordings for your interview. All right. Okay, moving on to the next topic. So that rounds out the FIDO conversation and the libel conversation for right now. Another small element that the book introduced that I want you to know is the idea that our speech can have time, place, and manner restrictions put on it so that society can function. And so what I want you to know about that is there are certain guidelines that can be put in place concerning certain types of expression, certain types of speech, where you could maybe do them in one place but not in another, or do them at one time but not in another. I'm going to use the idea of loud music. Okay, so loud music, music is an expression, listening to our music is an expression, but listening to loud music late at night, your city can put a restriction on that. And so in order for the city to do that, there are 4 ways that they have to make sure, 4 things that they're abiding by. The rule must be content neutral. The rule must not be a complete ban on one kind of communication. So with content neutral, they can't just ban one type of music and not the others. Or they can't say you can't listen to loud country music at night, but not all other types of music. They also can't put a complete ban on a kind of communication. You can never listen to loud music. The rule can't be like that. There needs to be a substantial public interest to justify the rule, okay? And so At night, when most people are trying to sleep, that is a substantial public interest to say you can't play super loud music past 10 p.m. Okay, that's in the public interest. And then it must be narrow in definition to not restrain more expression than necessary. So, for example, the law couldn't say there can never be any loud noises past 10 p.m. Because what about something like fire alarms? What about an ambulance that has an emergency, right? Or is going to an emergency? And so it can't restrain a extra speech that isn't necessary. So loud music, we can look at all of these rules, how yes, there could be a ban on loud music from 10 p.m. to 6 a.m. And if you break that rule, you're probably going to get a ticket and have to pay a fine. Okay, another example of time, place, and manner restriction that college students would likely be familiar with is that people can come and preach or protest on our campus in the open public spaces outside, but those same people cannot come into our classrooms and interrupt us with those messages. We can restrict the location of their speech on campus so that we can continue with our educational goals inside the classroom. That is a place restriction on a type of expression. Okay. Then, shifting gears, I would like you to know that the broadcast medium has more restrictions than print and internet mediums, and that is tied up in the history of early broadcast. The history of early broadcast is tied to radio technology on ships at sea and their ability to communicate with each other. That's how radio technology started. It didn't start as a mass medium for news and entertainment. But once radio technology starts taking off more and more people want to use it for news or entertainment, there is what we call a spectrum scarcity on the airwaves. This is like in the 1920s. More people want to broadcast, and at that time, broadcast was only done over airwaves, and there's a limited amount. So people wanting to broadcast all their different music or messages or whatever they were doing at the time, it became chaos. Leaders in the broadcast industry at the time realized that self-regulation wasn't going to work. They asked their government to help. The government creates an agency known then as the Federal Radio Commission, which later becomes the Federal Communication Commission that we know today, the FCC. So the FCC regulates broadcast communication, regulates public TV and radio communication. There is no such equivalent of regulation for the print or internet mediums. Therefore, we can say that print and internet mediums have more First Amendment protection than the broadcast medium because there's no regulating agency for print and internet like there is for broadcast, which is the FCC. Okay. And that helps us understand what is known as a platform-specific restriction. Broadcast specifically has a bit more restriction than print or internet. All right, and then the last couple of things I want to talk about, this is more going to be when you start using visuals in your projects. We are concentrating in 2033 on written work. Copyright and especially trademark come more into play when you're gonna maybe put visual elements with your story, but we do want you to know a little bit about them now. All right. Copyright and trademark deal with intellectual property. Intellectual property is any product of the human intellect that the law protects from unauthorized use by others. All right, I'm going to start with copyright, then move to trademark. So copyright is a form of protection provided by the law of the United States for original works of authorship, okay? So our media work falls into this, our stories that we make, our video packages that we make, commercials that we make, a documentary that you might make, photography that you take, all right? So what does a copyright do for the author, for the owner, for the one who holds the copyright? It gives the person who created the content the right to reproduce their own work, to publicly distribute it, to publicly perform it. Like, let's say it's a play, let's say it's a song, to publicly display the work. But other people who don't own that copyright should not be doing that unless they have permission from the copyright holder. So, what does copyright mean for those who aren't the author, who aren't the owner, who aren't the copyright holder? Okay, before someone uses copyrighted work, before they print it, broadcast it, dramatize it, reproduce it, they should get the consent of the copyright owner. So, for example, if you wanted to use someone else's photo to go along with your news story on a website, okay, you need to get permission from the person who owns that photo, who took it, or who owns the right to it. Okay. Now, those who distribute copyrighted material without permission, you could be sued for copyright infringement. Now, it usually doesn't start like that. It usually just starts with someone asking you to take down the copyrighted material. But if you would like keep using copyrighted material, not listen when they ask you to take it down, if you become known as like a person who's going to do this over and over again, um, you could find yourself being fined. It could be a lot of money, between $700 and $30,000. There have been cases where people have been fined more, but on rare occasion, if a person won't stop after being asked time and time again, you could actually go to jail for infringing on someone's copyright. This is why we harp so often about don't just take a visual from the internet and use it with your own work, because you need to check to see if it's copyrighted, and if it's not, you need to get permission. And if you can't get permission, you need to find a different visual. Any work fixed in a tangible medium is eligible for copyright protection. That's pretty much all of our media work. There is a type of there's a way around copyrighted material, which is called fair use, right? And we're going to go more into this in class. I'm not going to spend a ton of time on this video, but what I want you to know is fair use has a variety of categories that you're going to go more in depth to in the future in media law class. But two I want to talk about right now: the purpose and character of the use. If it falls under educational or informational use, you could be allowed to use copyrighted material without going to the copyright holder. Journalistic uses usually fall under that process of fair use, but it would typically be to like quote material from a bigger piece of media work. You're not using all of someone's copyrighted work in your story. Maybe you're quoting pieces of it. Maybe you are using a couple of visual elements. But if you're using it in terms of journalism, you are probably going to be able to do that under fair use. But PR and advertising, or those working on fiction projects, they can't really claim that, because PR work, advertising work, and fiction work is not typically thought of as educational or informational. Then also the amount of the work that you're using. If you're using a small amount of a big work, like then it's more likely that you can justify it under fair use. But if you're trying to use like an entire documentary and put it into your media work, that's not going to work. But if you're using like a snippet here or there to help tell a story, that might be okay. All right. So fair use can help us use some copyrighted material without needing permission, but it is narrowed and small categories. Couple additional facts about copyright I would like you to know for now. Currently, a copyright lasts for the life of the creator plus another 70 years. After that point, works go into the public domain and people can use them without having to worry about copyright infringement. That's the main thing I want you to know from this slide. Then a bit about trademarks. Trademarks are different from copyright. Okay, copyright is a whole bunch more categories. Trademark is specifically something like a name, symbol, or device or combination thereof that is used by a company or individual to establish a distinguishment of its goods and services from others, right? So a trademark is like these logos over here, these very famous logos that I'm sure you guys are familiar with: Apple, McDonald's, Google, Facebook, Disney, okay? Those visual elements right there, some of them contain words, some of them don't. Those are trademarks. If you use that in your media work, and especially you're trying to like pass it off as your own in some way, or degrade the brand in some way, you might be infringing on a trademark. And this is a situation where you could go to civil court, not count, civil court. So while with trademark infringement, you're not going to go to jail, you could have to pay a fine. And just like with copyright, those fines can end up being a lot of money. So don't infringe on people's copyright, don't infringe on people's trademarks. There are some legal ways that you can use trademarks, and you'll talk more about those in class. Okay. But in general, you don't want to just put them into your work and not clarify why you're using them. But you'll talk more about that in class. Hopefully you'll understand a bit about that. And that is the law briefing. I know it wasn't that brief, but that'll set you up for a little bit of legal knowledge that we would like you to have at this point in your Gaylord major. All right, I will let you guys go. See you on the next video.